Item for pronouncement of judgment. Item number 1, criminal petition 618 of 2023.
Petition dismissed. Highly open.
For motion, bail application item number 2.
May please Lordship. This is second bail application. Lordship, kindly call for LCR Lordship, CDO,
From voice court,
Kamrup Metro.
Additional session is
Additional-
Kamrup Metro.
Additional 3 FTs.
places to call for scan copy of the record and up to date status report at the Court of Learned Additional Session Judge FTC 1-3.
3, Lordship.
FTC 3. Fixing the matter on. Okay.
On 10th June.
Okay.
Item number 3.
Here also matter has been sursited, Lordship.
It is earlier rejected by your lordship and the lordship charge sheeted case lordship.
So
Record
what
will
is
be
the, what is the ground for filing the
Lordship
second-
kindly have a look at earlier order page 32. Page 32.
So 6 months.
Lordship,
So trial court will
no,
to conclude
no,
the
no.
trial within 6 months.
lordship, but more than 8, almost 8 months, lordship, over lordship,
Pardon?
almost more than 7 months,
Elapsed.
past lordship.
But solely on the ground of delay, can
And
this court grant you
also
bail?
merit also lordship, I
Pardon?
on merit also lordship. On
Merit
merit
also.
also.
No, merit cannot be considered because earlier we have consulted the report of the learned court below. Second application is maintainable only on the ground of change of circumstance in your favor.
But-
Of course, this may be a change of circumstance that the court below has failed to complete the trial within stipulated
Lordship,
period.
This is
But
one
the
and
question is, can this court grant you bail only on that point?
lordship,
Mhm.
that can be considered lordship or not.
That can be.
Lordship.
Okay, let us call for the case,
Right.
case record from the learned court below along with the scan up to date status report. But there is one judgment of Supreme Court. Kalyan Sando Sarkar versus Rajesh Ranjan alias Papu Jadhav. Their Supreme Court stated that only on the ground of delay, bail cannot be granted in serious offences.
Lordship, 21C is involved here.
Ah.
Commercial.
But there is other cases lordship.
Which one?
Nitish Adhikari and the lordship Muslimuddin's Nitish Adhikari in the case of Nitish Adhikari, it is after one and
But there's a
1 year, 7
order
months.
is earlier in point of time and by a bench of three judge bench decision.
lordship, there are some other.
Judge
decisions
bench.
also,
Okay, you
then I-
produce those
then I
judgments,
will
we will
like-
see. Scan copy of the record and up to date status report, fixing the matter on sorted COVID
On 5th June.
from which court?
Lordship is special judge.
Karimganj.
Current non
On
special.
5th June.
Okay.
Item
Okay.
number 4.
My lord, in this case, all the petitioners, they were arrested on 22/4/2024. And they were arrested because they were engaged with labor to unload the stolen articles. You also kindly say FIR page 13. We filed the bail application before the court below.
Oh, the other day, perhaps the bail application of Mr. Mohammed Asikul Islam was dismissed by this court.
This is another person.
Another,
Another.
this is not that person.
No, not that one. Those two Asikul is the main person. He stolen all he passes all the items. And
Oh, how
This-
long you were behind the bar?
my lord, we are 11.
Date of forwarding is 2204.
2201.
05 or 4?
Yes,
4, Lordship.
Oh, 4.
page 14, my lord.
Okay, produce the case diary.
Yes, let us call for the case diary. This is
Other
from
only,
Hajara case.
only I come to learn just now.
Ah.
Both the petitioners are feeling ill in the hospital. So first that may can be given, my lord.
Both the
Both the petitioners
are
are
suffering from
ill, feeling ill.
what kind of ailment?
But they are not disclosed. One is suffering from heart, asthma.
Hey, you obtain necessary instruction. No.
Then the short that may can be given.
Okay, CBN, madam.
Hazara,
Let it be on 30th, Lordship, 31.
Okay.
30.
31.
Sorted, possible if possible.
Lordship, can it be on 29th?
Yes.
Sometime June, my lord, no, my lord, it will next week, my lord.
May.
Oh, May.
Item number 5,
30. 29.
May I please, Your Lordship? For 13 application, my lord. FI is page 12. 13 is the origin, my lord. May I read, my lord?
Yes.
To the officer in charge, Shivsagar Police Station, subject FIR regarding missing of iron pipe. Sir, which refers to subject as cited as iron, like confirm that some miscreants have stolen iron pipes on so and so evening from nearby area of RCB bridge number 1/1 over River Dimu at Sologuri on Khoripati Ali. The same materials were seized from your end with vehicle number so and so. Please be informed that the materials as mentioned above are
Madam,
damaged.
recently we have allowed one bail
Lordship, I
application.
have annexed the order also, my lord.
That's all
Page
right, but
15.
madam, the case diary may be available in your office.
Lordship.
Can you obtain instruction
Yes, Lordship, we can. Lordship.
after some time?
After some time.
Lordship.
If it is available, Lordship.
Yes.
Lordship.
item number 11, for admission, foreign method.
May I please?
Hmm.
This is an application, my lord, for transfer of two cases pending before the of the Chief Judicial Minister Lakhimpur and one at Jorhat. Before the court at Sub-Regional Minister pending at Kamru Metro. What is the in this case, my lord? I was a director of an organization, namely the responsive organization that is dealing with cheat fund, my lord. It's relating to cheat fund case where members of public had deposited money, but we failed to return the money. And it was done in many places all over Assam, my lord. In fact, if your lordship take up first FIR, my lord, which is lecture 1, page 15, my lord. It was lodged by one Pukeshwar Borua, is a resident of North Lakhimpur, my lord. And he lodged FIR against 3 persons, Jyotish Gogoi, director, present petitioner as a managing director, and Rinkumoni Bora is another person. Due respect, I beg to inform you the above mentioned accused person as director, managing director, and partner of Responsive Real Estate Construction Private Limited. Having his office at Rongor Sariali, Goengaon, Shivsagar district. And the aforesaid person has collected huge amount of money from public by giving false assurance through their appointed agents and collected money from various places of Assam. They purchased land in various states or places of Assam in the name of the company. After they have muted their land in their own name, they cheated the crores of the collected money and blocked the seal of the said office of the company, and accused person now fled away. The aforesaid accused person opened a branch office at North Lakhimpur, Sodor Police Station, Sariali, Ward number 8, and collected an amount of 1,20 lakhs from the public at that locality. The above mentioned, accused number 2, Vikas Borgoy, was arrested by police in Shivsagar and kept in police custody. So that is the case, my lord. And this case ended in search sheet, your lordship. And search sheet was filed by charge sheet number way back in 2018, my lord. And then the trial is commenced in that case, my lord. And there's another case, my lord, that was lost, page 29, before the Superintendent Police Dorat, my lord. It was filed by one of the Grahak agents of the Suraksha Committee, office of the real estate company, my lord.
The second FIR is at page number?
Page number 29. my lord. The below name, page number 29. my lord. It says that with due respect, we understand beg to submit as follows. Below named persons are the directors, partners of Response Real Estate Construction Private Limited, Company Registered Company Act. The said person opened many branches within the state, also opened branches in our office or jurisdiction, therefore collected huge sum of money and acted like a bank without having a license from RBI. From initial stage, the director made criminal conspiracy to cheat the innocent investors as well as agents and grab bulk sum of rupees. The below name accused person collected crores of rupees from the investor and shut down their branch office at the time of maturity. At present, they're fleeing away. It is therefore prayed that your good self will be kind enough to take measures as per law for the injured justice. The accused persons are Jyotish Gogoi, Vikas Borogohai, and Rinku Mani Bora. And this case also ended in charge sheet, Your Lordship, and charge sheet was filed in 2016, and trial has commenced before the court of CCM, Jorat. Now the main case, my lord, what has happened? Bureau of Economic Offences. Bureau of Economic Offences, my lord, when appeared in the newspapers, they have that taken the matter taken the matter on its own mind, and they made a discreet inquiry under the provisions of CRPC, my lord. And after making inquiry, the inquiry report was submitted, and on the basis of inquiry report, they lodged an FIR that your lordship will kindly come to page 46. It was lodged by one Purobi Muzumdar, APS, Regional SP, BIA. Page 46. There your lordship will find. With reference to above, I like to inform you that an inquiry was initiated in BIO against a non-banking financial company by the name Response Real Estate Construction Private Limited, based on news item published in Assamese Daily Ahmed Protiti. The mainstay of the allegation regarding collection of huge sum of money from the public through various fraudulent schemes and later on fleeing away without repayment of any money and maturity. So allegation same. Inquiry number so-and-so was initially addressed to the inspector C.K. Boro, subsequently re-endorsed to me. During the course of inquiry conducted by the earlier inquiry officers as well as by SEL, it was found that the directors of Response Limited, subsequently styled as Response Real Estate Construction Private Limited, had criminally conspired, endowed in cheating and misappropriation of public funds under the false promises of good profit under various fraudulent schemes by opening branch offices in different places in the district of Assam. During inquiry, the statement of victims and investors were recorded. Many number of booking allotment certificates, money receipts were also collected, which revealed that directors, partners of Response Real Estate Construction were running their fraudulent activities in various districts of Assam, had engaged illegal collection and swindled huge amount of public money in between 2009-10 to 2014. Therefore, they further misguided and caused many innocent people to invest their hard-earned money into the fraudulent scheme, later on fled away from the subsequently closing their branch. Same allegation. In light of the above facts and circumstances, genuine complaints of the victims, I request you kindly register a case under the appropriate sections of law against the director, partners of Responsive Limited and co-associates as revealed during the inquiry, which are mentioned in below. So there were 6 persons were named. My name appears as Vikas Borogohai, my lord. That is accused number 2, my lord. Now this case was registered, received as a BIA case number 19 of 2020 under section 120B 420-406, read with 4 and 5-6 of the PCA and MHC Act, read with 5 of the APDI Act, my lord. Now, subsequently, in 2020, that next page, your lordship, Annex 7, page 48. This case, a charge sheet was submitted in 2022 by charge sheet number 14 of 2022. And the charge sheet, if you go through the charge sheet, there are many documents, the original record book of the response agreement, all the agreement copies, made by this construction company, the maturity registers and other booking allotment certificates, the name of different persons in all over Assam were seized, my lord. Total more than hundreds of documents were seized, my lord, that your lordship will reveal from the MR number 62, 72, 2022, page 49, 50, 51, 52, 53, 54. These are all the various certificates, my lord. And 56. And in the charge also, that a revenue charge that has been defined, and altogether, they have also examined many witnesses in this case. Altogether, they have all the investors all over Assam were examined, and the total more than 26.
Whether the first informant of the first FIR and the second FIR are witness in this case,
That
BIU case.
that have to tell you. Huh? No, the first FIR was lost by one, sorry, Your Lordship. One was Kukeswar Borua, my lord, of Lakhimpur.
Then another legal question is whether this FIR is maintainable
Which
on
one?
the same fact.
That is the question.
This FIR recorded, registered by the BIO.
BIO maintainable because they have taken every districts of Assam, my lord. It was thorough investigation was conducted, my lord. And all the documents, relating documents were seized, my lord. Not Lakhimpur, Sibsagar, Jorhat, everywhere, my lord.
But in respect of those FIRs in Lakhimpur and Jorhat district, how can you investigate the case? How can the BIO investigate the case?
Because it was entrusted the government of Assam, my lord, to conduct the investigation. Because there was a
That's
class.
all right, but in respect of those FIRs, this is a second FIR.
I understand, but second FIR, your lordship, because modus operandi is same, my lord. Because allegations your lordship has seen, both the FIRs as well as the FIR lost by BIO is same, my lord. Only they have conducted.
No, first they will tell me whether the witnesses in those two FIRs in Lakhimpur and Jorhat
Yes, my lord.
are the witness of BIO case or not.
That part I have to look into, my lord.
Okay, then you go through the same.
But question is that one important if I'm praying for a joint trial, basically. Because, and moreover, if I'm convicted or acquitted, any of the two cases where trial is going on, then if you have for the same offense, if I
No,
prosecuted in the
merit of the cases may be different in Lakhimpur and
no, not different. Same allegation that I have collected money and I did not pay the maturity, I fled away from by closing the office. That is the allegation. Sum and substance of the allegation is the same. Now, if I am acquitted in or convicted in Lakhimpur case or Jorhat case, what will be the fate of this case? Because whole of state of Assam, including Jorhat and Lakhimpur, were also included in Guwahati case. That is
so
important.
you first satisfy those requirements, those questions put by me.
Well, that's why my first submission is that it's a case of joint trial. Since the offences are
No, in the transfer petition you cannot pay for joint trial.
the accused can pay because where accused can pay because it's question of prejudice will come here. Because question of prejudice will come, my lord. Because naturally,
No,
because
yeah, the occurrence may take place over a period of time.
yes, they have
It is,
that period covers more than because that.
Issue of
Because-
joinder of service may also come here.
Yes, understood. No, your lordship will find that in the FIR they have categorically
If
stated.
some of the offenses took place in different point of time, you cannot join them in one trial.
I understand, my lord, but one thing because in the case of Lakhimpur, my lord, they have not given the date actually that it was commenced. But in BIO case, they specifically stated this is the period where they will be operating. It encompasses all the various districts or some we have opened the office. Because the documents will speak itself. They have seized the documents from the custody of the various offices.
Okay, then you go through the record, you appraise this code on next that,
Because-
that whether the complainant and the victims
Yes, ma'am.
of the FIR of Lakhimpur and Jorhat
Yes, ma'am.
are the witness in this BIU case or not.
Yes,
On next
that aspect I can look into, my lord.
Yes.
And one more thing that is that question of prejudice will always necessarily come, your lordship can see. First of all, the section 300 will come, my lord, because if I'm
Section?
acquitted, if I'm acquitted or convicted, whatever it is, in those cases where trial is pending, my lord, naturally it will affect this case also, because it covers the district officer for the same offense. I cannot be tried again by BIO.
No, place of occurrence, date of occurrence are different, no?
Place of occurrence was also, they have also taken in the place of occurrence of Jorhat also under consideration, my lord, in BIO case, my lord. Because all documents relating to Jorhat case were also seen.
Okay,
So that is another legal aspect is there, my lord.
we'll examine all the aspects. We'll see.
And because the Justice Chandrachud's recent judgment is there regarding joint trial, he has given details of how the joint trial is to be conducted. Question of prejudice will come, my lord.
Okay, produce that judgment also.
So that is,
We'll see.
2022, my lord, that is.
Next date,
Next with you, Nasim Singh, my lord.
third, Mr. P. Kotoki, Learned Counsel for the petitioner, and Mr.
D. Borua.
Learned Counsel for the respondent number. Two. And Madam, you for respondent number? One. Party court, list the matter on. Kobe,
On
Sorted.
7 June,
sort that,
5th June.
5th June, 5th of June.
Lordship, I am for 2 and 3. That's
For
what.
the informant, my lord, yes.
Both the informant.
What do I informants? Now, can the, whether the trial of those cases will be stayed, my lord?
No, not now. First, they've satisfied the court, we will consider it.
Yeah.
Mock dead hearing, item 6.
May I please, your lordship?
Yes, on the other day, I have referred the case of
Yes, yes.
Nawaz Khan.
Yes, my lord.
Yes.
Regarding that case, my lord, judgment which was passed by the Supreme Court by criminal appeal number 1043 of 2021. It is reported, my lord, arising out of SLP criminal number 1771 2021, my lord. My lord, regarding this judgment, I am satisfied, my lord. I am fully support. My lord, I have to go the back in the case, my lord. First of all, my lord, this applicant, my lord, Muhammad Nawaz Khan, was arrested on 26 March 2019, along with 2 other accused, my lord, which are Rafiquddin and Arif Khan, my lord. My lord, after the arrest, my lord, this petitioner, my lord, applied the bail application before the additional district session judge, my lord. And that bail application, my lord, was rejected, my lord, 27 June 2019, my lord. After rejecting the bail application, my lord, this Muhammad Nawaz Khan, my lord, applied the before High Court for bail application, my lord. After the hearing the both side, my lord, the Honorable High Court, Allahabad High Court, granted bail, my lord, with some condition, my lord. He should be appear regularly in court without the permission of the court, my lord. He don't to go other place, my lord. After getting the bail, this applicant, my lord, did not appear the trial court, my lord. And for which, my lord, trial court.
No, that is not my point. My point, their position is discussed.
No, my lord. The issue is that, my lord, when he did not appear the trial court, then, my lord, NCP filed a criminal appeal before the Supreme Court.
No. There the principle of position is discussed.
Conscious position, Lordship.
Regarding, I am coming, my lord. This, my lord, judgment was
No,
passed
we
by
are
issuing,
not
my lord.
on that.
My
We
lord,
are-
kindly see the page number. This judgment, my
No,
lord,
Mr.
31, 32,
Rahman.
my lord. 31, 32, my lord, current judgment. my lord.
No.
Where they clearly mentioned, my lord.
That judgment was referred only to ascertain this position.
No, my lord, here they
No,
clearly mentioned.
no other
My
fact.
lord, I want to give my lord, place this judgment, my lord. Was the passed by the Supreme Court, my lord. That is judgment, my lord. Kindly is the one paragraph, my lord. It clearly mentioned, my lord. Yes. 31 and 32, my lord. Cover this case, my lord. This paragraph, my lord. My lord, kindly see the page,
No,
31 paragraph.
this is the order of
My
High
lord,
Court.
Nawaz Khan, by the Supreme Court, my lord.
this order.
Yes, my lord. Judgment, my
This
lord.
is of Allahabad High Court.
No, no, my lord. It's Supreme Court. What is that? MD Nawaz Khan, Union of India through NCB. My lord, can is the para 31, my lord.
Hmm?
31, my lord.
No, we are not concerned with the fact of that case.
My
We
lord,
are
by issuing
concerned
this fact, my
only-
lord, the Honorable Supreme Court reject the was the order, my lord. The earlier part by the Allahabad High Court, my lord.
No, no,
By
no,
issuing
no.
this matter, my lord, here clearly mentioned, my lord.
No,
Only this issuing, my lord.
what they have decided, we are not concerned with that.
My lord, only
We are
this
concerned
issuing,
with
my
the
lord.
principle of law laid down there in respect of possession.
In 34.
No, my lord, they regarding that, my lord, here clearly mentioned, my lord.
No,
Please,
no.
my lord, kindly, sir, 32, my lord. Here clearly mentioned, my lord. May I read, my lord, please, my lord?
No,
may I-
sorry.
may I read?
That was not the
My lord,
question before the court.
When the accused did not appear trial court,
No, no,
then
no, that is
by
not the,
taking this issue, my lord, the Honorable Supreme
Sorry.
Court, my lord, was
Sorry.
the earlier High Court's order, my lord.
sorry, that is not the question before this court. Question before the court is possession.
Yes, my lord. I am coming to that point, my lord. I have collected, my lord, some others orders, my lord, from the other honorable courts, my lord. Should be the. My lord, I have placed two orders, my lord. And it's the Kishore Bira versus State of Odisha, my lord.
This is on what point?
My lord, yes, the clearly this is about the possession, my lord. My lord, kindly is the paragraph number
Sorry?
9, my lord.
Which part?
My lord, paragraph number 9, my lord. Kishore Bira versus State of Odisha, my lord. Second page, my lord, paragraph number 9, my lord. What 2002 within bracket 7 SCC 419. Paragraph, the Honorable Supreme Court in the case of the Avtar Singh and others versus State of Punjab held that the word of the possession no doubt has different sets the meaning and it is quite elastic in its context, my lord, paragraph 9, my lord.
Yes, what is the strength of that bench of Supreme Court?
My lord, regarding
is,
possession, my lord,
this
the conscious
Nawaz Khan-
possession, my lord.
Nawaz Khan is of 3 judge bench. Then what is the strength of this bench? This Avatar Singh and
My lord,
others
reported,
versus
my
State
lord,
of
of
Punjab?
2002, my lord, 7 HCC 419, my lord.
How many
this-
judges were there?
My lord, that not mentioned, my lord, here, my lord.
You must ascertain only thereafter referee,
Yes, my lord.
because Nawaz Khan is 3 judge bench decision. So if this judgment is of 2 judge bench, then definitely Nawaz Khan will prevail over this judgment.
And what in my case, my lord, now, my lord,
Hmm.
I have come, my lord, my case, my lord.
Hmm.
In my case, my lord. My lord, kindly, sir, page number 18, my lord, FIR, my lord. My bail application, my lord. My lord, FIR, my lord, page number 18, my lord.
Yes.
Yes, my lord. From the beginning, my lord.
Hmm.
Governor so and so. Is my lord, district Motihari, Bihar, my lord, following the items were recovered by me. It is
Hmm.
submitted by the IO, my lord.
Hmm.
The search from the possession the accused person which was kept concealed in an extra chamber while inside the vehicle, by smuggling the suspected NDPS substance in the other state, my lord, that is Bihar. During the course of search, recovered the NDPS substance. One welding machine was used to take the NDPS substance from the extra chamber, which was made in the vehicle in such a way the decide in order to the trafficking the in NDPS substance to other parts of the state, my lord. My lord, my submission is that, my lord, this NDPS article, my lord, recovered from the extra chamber which is inside the truck, my lord. It is ultimately 100% aware of the owner of the truck, handyman of the truck, and driver of the truck, my lord. He's not in this case. He's not connected in this case, my lord. You are just traveling by the truck, my lord, in the cabin side, my lord. The truck was going to the towards, my lord, Bihar, my lord. That is a native place of this present petitioner, my lord. For his, my lord, he was traveling by this truck, my lord. He is not involved, my lord. And this article, my lord, never, my lord, recovered from this the present petitioner, my lord. In the inside of the truck, my lord.
But the fact remains that you are one of the passenger of that truck.
Definitely, my lord. I am editor, my lord. That is my fault, my lord. I was traveled by the truck, my lord.
Now you come to the principle laid down in the case of Nawaz Khan by Supreme Court in respect of this position.
34, Lordship. There are 34. And see.
Yes. Para number?
34. 15 is also there. 15 in 15 it is discussed first. Lordship, we have to for 34.
No, there's you are referring to SSC.
Lordship, yes. Para 15. At the present stage, it is material to note that
This section 20B makes position from there
no, Lordship.
or the expression position.
Lordship.
So, Mr. Rahman, the judgment you have referred to starts from this 22, the expression position.
Yes, ma'am.
Read it.
আপনার বেরিং মোর বেরিং হবো আপনি ওই বেরিং মই এসএসসি অনলাইন এসএসসি প্ল্যান আছে Lordship. The expression position is a polymorphous term which assumes different colors in different contexts. It may carry different meanings in contextually different backgrounds. It is impossible as was observed in supernatural and remembrance of Legal Affairs, West Bengal versus Anil Kumar Punja to work out a complete logical and precise definition of position uniformly applicable to all situations in context of all the status. The word conscious means awareness about a particular fact. It is a state to mind which is deliberate in intended. Once position is established, the person who claims that it was not a conscious position has to be established it, because how he came to be in position is within his special knowledge. Section 35 of the Act gives a statutory recognition of the position because of the presumption available in law. Similar is the position in terms of Section 54, where also presumption is available to the drawn.
On 7 June,
So till then interim order dated 8/9/2023 is then extended. Fiction.
7
And Mr. B. B. Chaudhary, learned counsel for the applicant, may file affidavit indicating the date of his appearance before the IOD.
Yes, highly ordered.
my lord, kindly order may be furnished on me, my lord.
Okay, a copy of this order will furnished to Mr. Sharma during the course of the day.
Item 14. Fourteen also, my lord, my same prayer, my lord. As per telephonic instruction, my lord, I was informed, my lord, that he has not appeared.
As per my client's matter, he instructed me that he has appeared, even granted bail matter. By the IO.
Same order.
22nd, no, I may be filing an affidavit matter.
Send it, 7 June. Item 15.
Diplo.
See, 15, my lord, I have received the case there.
You have received it. Is there receipt?
Yes.
Is there any material against him?
Yes, my lord, the two person, my lord, arrested, my lord, from the spot, my lord, along with that, my lord, stolen, my lord, 2 cows, my lord. And my lord, in their statement, my lord, they have categorically said that, my lord, I have read that portion, my lord. অলপ পাছত এখন গাড়ীৰ পৰা কেইজনমান লোক নামি আহি আমাক সোধা পোছা কৰি থাকোতে আব্দুল কৰিম কাদিৰ মহিদুল ইছলাম প্ৰেজেন্ট পিটিশনাৰ এণ্ড মাই লৰ্ড মুকলেছ আলী আৰু আৰিফুল ইছলামে আন্ধাৰৰ সুযোগ লৈ ঘটনাস্থলীৰ পৰা পলায়ন কৰে। So they are also there, my lord, along with that.
There are 2 kettles, lordship, and kettles have been recovered, lordship, and only section 379 is there, lordship, or the kettle section is there.
Pardon?
Lordship, 2 kettles.
Maybe, but merely because only the punishment is of 3 years, we should not consider the prima facie case.
That's it. The kettles are already recorded, lordship.
Recovered, my lord, when my lord order, my lord says them, and my lord in the railway, my lord crossing, my lord, they were apprehended.
So, what is the material in the case diary?
Case that,
Can-
my lord,
can I say?
the my lord owner file, the cattle of the owner file is my lord FIR, my lord. He said, my lord, that he is from his cow shed, my lord, two my lord cows stolen, and my lord when he
2 or 1?
my lord, 2, my lord,
2 different, yes.
2. And my lord, regarding that, my lord, 1, my lord, Gao Pradhan certificate is also there. That, my lord, 2 person, two, my lord,
No,
cow was stolen.
where it is mentioned in the FIR, 2 cows were stolen.
Lordship, two cars were stolen from in different vehicles, Lordship. They were found to be in different vehicles.
Different way.
One in each car, Lordship, in vehicle, Lordship. And the petitioners are the owners of the vehicles. One Galeno vehicle and one another vehicle.
So you submit the case ID
My lord.
or Mr. A. Baker, learned counsel for the applicant, and Mr. B. Sharma, learned additional people for the state respondent. This para number 2 and 3. Page number 50. So what is your case?
The petitioners are the owners of the vehicle, Lordship. That is my only, and one thing I am to say that the kettles are already recovered, Lordship, so custodial detention may not be required, Lordship.
Mr. Decker, learned counsel for the applicants, submits that the applicants are the owners of the vehicle from where the stolen cows were recovered, and they are not entangled with the offense alleged in the FIR. And the investigation might have been completed, and as such, their custodial interrogation may not be required, and therefore it is contented to allow the petition. On the other hand, Mr. B. Sharma, learned additional BP, has filed the case before this court and submits that the IO has collected materials in support of the allegation made in the FIR. And therefore, Mr. Sharma has opposed the petition. After this, having heard the submission of learned advocates of outside, I have carefully gone through the petition and the documents placed on the record and also perused the case area with the assistance of Mr. Sharma, learned additional 50. Case area indicates that the IO has collected sufficient incriminating materials against the present applicant. Investigation is going on and some of the co-accused are yet to be arrested. and extending the privilege of res bail to the present applicant will hamper the investigation. Having considered above, and also considering the nature and gravity of the offense and the punishment prescribed for the same, this court is of the view that this is not a fit case where the privilege of res bail can be granted to the applicant, and accordingly the petition is dismissed. Case derivative.
Item 10 for others.
May I please, Lordship. Lordship, may kindly have this order dated 8/5/2014, Lordship,
May-
as a direction to make
May I please, Lordship?
50% of the amount, but he has
My-
the paid, Lordship.
My lord, I have to file an affidavit, my lord, due to illness, my lord, of the private, my lord, petitioner, my lord. So my lord, sometime may
That
be
is the file,
required, my
Lordship,
lord.
but that direction may be complied with, Lordship. Last line of the order.
What direction?
Lordship, order dated, Lordship,
At least
8/5
50% of the area.
area amount, Lordship.
Okay, you cleared up 50% of the area.
My lord, yes, I am, I will obtain instruction to that effect, my lord.
No, no,
Whether-
not obtain instruction.
paid or
You
not,
have
my
to produce the document of payment of the amount before the trial court. Next date. Your instruction will not do. Because we will not hear you unless you deposit the amount we have directed to pay to the respondent. You comply with the order. The order was passed on 18/4/2024. 1 month
So-
already elapsed.
But my lord, at this moment, my lord, 50% out of total amount, my lord petitioner is not able to pay, my lord, entire.
No, then
50%.
you
So my
have
lord,
to go, you have to go to jail then.
He is a headmaster,
Come-
Lordship, now he is
You
getting
have to go to
50,000
jail.
salary, Lordship.
he's suffering illness, my lord.
You have to comply with the order of the court.
My lord, may I pay, my lord, on installment basis, my lord, I will pay, my lord. That part will be clear.
You make payment, you show your bona fideness. Only thereafter will consider that payer. You pay some of the amount. What is the 50% of the total amount?
Actually, about 3 lakhs, Lordship, now. About 3 lakhs, Lordship.
Above 3 lakhs.
Yes, Lordship.
50% is above 3
Yes,
lakhs.
Lordship. Just the payment has to be from the date of 2012, Lordship.
Oh, what is his source of income?
He is headmaster, Lordship.
Headmaster.
Yes, Lordship.
Oh.
And his income is, Lordship, now about 50,000, Lordship, now. Salary.
My lord, he's facing, my lord, different problem, my lord. He's,
So, why don't you file an application before the court below for attachment of his salary?
Yes, Lordship, because the stay order is also there, Lordship. And
Where? Here.
Here, Lordship. Not stay, Lordship, you have to give some election is given, Lordship, to make 50%. And he is, Lordship, given the only current salary, current maintenance, Lordship. But area he has forgotten about it.
50% of monthly maintenance, my lord, I am providing, my lord. But my lord, in respect of my lord, area, my
No,
lord.
no, you make payment.
And he is,
My lord,
Lordship, that's why he's filing.
If you,
one after another,
otherwise,
filing because
otherwise, we will direct the concern, this DEO
DDO.
to attach your salary. In that case, you will be in difficult.
My lord, some time may be granted, my lord, so that I can contact with my client.
Heard Mr. S.
discuss.
Hock, learned counsel for the
A.
applicant.
Hussain,
and
my lord.
Mr.
Oh, sorry.
M. Hock, learned counsel for the respondent number 1. Mr. M. Hock, learned counsel for the
My
respondent
lord, A.
number.
Hussain. A. Hussain.
A. Hussain,
Yes.
learned counsel for the respondent number 1. Mr. Hussain submits that due to some, no, due to ailment, the applicant, no, the respondent number 1 could not file the affidavit in opposition and also could not make payment of the 50% of the area amount. And price for granting him how much time? 10 days,
2 weeks, my lord.
14 days time. Fair is accordingly allowed. Recess shall raise the matter on
12 June.
12 June. On that day, Mr. Hussain shall produce the document, no, produce the evidence of payment of at least 50% of the amount before this court.
Hello, Your Lordship.
My lord, one prayer, my lord. Order of this item number, my lord, 14 also may be served upon me, my lord.
Order of
My lord, item number 14, my lord. Written, regarding written instruction,
regarding
written instruction, my lord.
with Comic or APA.
Okay.